In the United States, bankruptcy courts have the equitable power to subordinate claims or place superior claims behind inferior claims based on fairness. In the 1958 case Costello v. Fazio, the Ninth Circuit considered whether a court could subordinate a corporate insider's claims against a bankrupt corporation under the doctrine of equitable subordination. In 1948, J.A. Fazio, Lawrence Ambrose, and B.T. Leonard organized the partnership Leonard Plumbing and Heating Supply Company. Initially, Fazio contributed about $43,000 in capital, Ambrose contributed about $6,500, and Leonard contributed $2,000. In the fall of 1952, the partners decided to incorporate. In contemplation of incorporation, Fazio and Ambrose each withdrew all but $2,000 of their own capital contributions. As a consequence of the withdrawals, the company was left with only $6,000 in total capitalization. In addition, the partnership issued promissory notes to each of the two partners for their withdrawal amount. In 1953, following incorporation, the corporation assumed the partnership's liabilities, including the notes to Fazio and Ambrose. But in June of 1954, after suffering continued losses, the corporation filed for bankruptcy. At the time, the corporation wasn't indebted to any creditors, which meant the promissory notes issued to Fazio and Ambrose were given priority claim. In the bankruptcy action, Fazio and Ambrose filed claims against the bankrupt estate. The bankruptcy trustee, John Costello, moved for the claims to be subordinated to the claims of general unsecured creditors. At a hearing, expert witnesses testified that the company was undercapitalized. The company's accountant also testified that the promissory notes were issued to reclassify Fazio's and Ambrose's capital contributions as debt to avoid taxation, and that the company was incorporated primarily to protect Ambrose's and Fazio's personal interests. The referee concluded that the company was adequately capitalized and that Ambrose and Fazio acted in good faith and didn't take unfair advantage of the corporation, shareholders, or creditors. Costello then filed a petition for review in the United States District Court, which affirmed the decision. Costello appealed to the United States Court of Appeals for the Ninth Circuit.